Subminimum wage is the Fair Labor Standards Act equal for disabled adults? Is it equal for special education students? The Individuals with Disabilities Education Act, passed by the United States Congress in 1975, is intended, quote, to ensure that all children with disabilities have available to them a free, appropriate public education that emphasizes special education-related services designed to meet their unique needs and prepare them for further education, employment, and independent living. Title 20 of the United States Code, Chapter 33. Special education from the student point of view. I was in special education in elementary school and middle school, experienced the consequences of it in high school and beyond. I'm David Potter. I survived special education, not a joke. Sub-minimum wage is the Fair Labor Standards Act equal for disabled adults? What does the law say? 214. Employment under special certificates, lowercase c, handicapped workers. 1. The Secretary, to the extent necessary to prevent curtailment of opportunities for employment, shall by regulation or order provide for the employment under special certificates of individuals, including individuals employed in agriculture, whose earning or productive capacities is impaired by age, physical or mental deficiency, or injury, at wages which are a. Lower than the minimum wage applicable under Section 206 of this title, b. Commensurate with those paid to non-handicapped workers employed in the vicinity in which the individuals under the certificate are employed, or essentially the same type, quality, and quantity of work, and c. Related to the individual's productivity. What needs to change in the law? Equal pay for the disabled using the same standard as the non-disabled. What does the law say? 2. The Secretary shall not issue a certificate under paragraph 1 unless the employer provides written assurances to the Secretary that a. In the case of individuals paid on an hourly rate basis, wages paid in accordance with paragraph 1 will be reviewed by the employer at periodic intervals at least once every 6 months, and b. Wages paid in accordance with paragraph 1 will be adjusted by the employer at periodic intervals at least once each year to reflect changes in the prevailing wage paid to experienced non-handicapped individuals employed in the locality for essentially the same type of work. 3. Notwithstanding paragraph 1, no employer shall be permitted to reduce the hourly wage rate prescribed by certificate under this subsection in effect on June 1, 1986, of any handicapped individual for a period of 2 years from such date without prior authorization of the Secretary. 4. Nothing in this subsection shall be construed to prohibit an employer from maintaining or establishing work activity centers to provide therapeutic activities for handicapped clients. 5. A. Notwithstanding any other provision of this subsection, an employee receiving a special minimum wage at a rate specified pursuant to the subsection, or the parent or guardian of such employee may petition the Secretary to obtain a review of such special minimum wage rate. An employee or the employee's parent or guardian may file such petition for, or in behalf of the employees, or in behalf of the employees and other employees similarly situated. No employee may be a party to such action unless employee or the employee's parent or guardian gives consent in writing to become such a party, and such consent is filed with the Secretary. B. Upon receipt of a petition filed in accordance with subparagraph A, the Secretary within 10 days shall assign the petition to an administrative law judge appointed pursuant to Section 3105 of Title V. The administrative law judge shall conduct a hearing on the record in accordance with Section 554 of Title V with respect to such petition within 30 days after assignment. C. In any such proceeding, the employer shall have the burden of demonstrating that the special minimum wage rate is justified as necessary in order to prevent curtailment of opportunities for employment. What needs to change in the law? This suggests that the employer in this situation is taking advantage of this law and would only hire if they pay disabled people less than non-disabled people. What does the law say? D. In determining whether any special minimum wage rate is justified, pursuant to subparagraph C, the administrative law judge shall consider lowercase Roman numeral 1, the productivity of the employee or employees identified in the petition and the conditions under which such productivity was measured, and lowercase Roman numeral 2, the productivity of other employees performing work of essentially the same type and quality for other employers in the same vicinity. What needs to change in the law? Comparing productivity between disabled and non-disabled is harmful to the disabled. What does the law say? E. The administrative law judge shall issue a decision within 30 days after the hearing provided for in subparagraph B. Such action shall be deemed a final agency action unless within 30 days the Secretary grants a request to review the decision of the administrative law judge. Either the petitioner or the employer may request review by the Secretary within 15 days of the date of issuance of the decision by the administrative law judge. F. The Secretary, within 30 days after receiving a request for review, shall review the record and either adopt the decision of the administrative law judge or issue exceptions. The decision of the administrative law judge, together with any exceptions, shall be deemed a final agency action. G. A final agency action shall be subjected to judicial review pursuant to Chapter 7 of Title 5. An action seeking such review shall be brought within 30 days of a final agency action described in subparagraph F. What needs to change in the law? At the time of this recording, the 117th Congress introduced the Raise the Wage Act of 2021. It is blatantly unfair for one group, the non-disabled, to be paid based on prevailing wages or minimum wage, while the other group, the disabled, is to be based on productivity in relation to the non-disabled. This isn't equal protection. This is privilege for the non-disabled. A disabled person could be more productive and be paid less, and the non-disabled person could be less productive and be paid more. That is, the disabled person surpasses the non-disabled benchmark but isn't paid to reflect it. How does this law impact my life? It doesn't apply to me. Unfortunately, SSI essentially makes this the only option because of the income and asset limits. I received SSI from age 18 to 38.
Is it equal for special education students? Is the Individuals with Disabilities Education Act working as intended? Is it preparing disabled students for further education, employment, and independent living? Visit the website at notajoke.net. I'm David Powder. I survived special education, not a joke.